Good evening and welcome to the maiden edition of the Ready to Run TV show dedicated to supporting youth candidates running in the 2019 elections. My name is Samson Itodo.
And I am Saadatu Falila Hamo. The Ready to Run show is a live TV program designed to inspire, support, and provide visibility to young people running for elective office in the forthcoming general elections. Additionally, the show will equip candidates with necessary tools for running effective political campaigns, promote issue-based political participation, and ignite active participation by citizens.
It's 41 days to the 2019 elections, and at the center of this debate is the question on whether young people possess the competencies for public leadership or the economic power to navigate the tide of Nigeria's expensive political process.
The Ready to Run movement was born out of the Not Too Young to Run campaign to inspire and support men and women aspiring to run for elective office. It is actually Africa's first comprehensive database of young people seeking for elective office in Nigeria. It serves also as well as a vehicle for training, support for these young aspirants.
There's no dull moment on this show, and this show has 4 interesting and captivating segments. First is the Ready to Run Lab, where we unpack the nuts and bolts of running effective campaigns.
Second is Get Out a Vote, where we provide useful information on voting and election. Third is the Ready to Run Lounge, a discussion segment where youth candidates are engaged on their manifestos, their campaigns, and motivations to run for office and be of service to us in our country, Nigeria.
Last but not the least is the Meet the Youth Candidates, where we profile competent youth candidates running for office in the 2019 general elections. This show is proudly brought to you by Yiga Africa and the Not Too Young to Run movement in partnership with Channels Television and supported by the European Union. You can be a part of this show by following us on Twitter at Ready to Run NG and Facebook Ready to Run NG. Share your thoughts and comments using the hashtag Ready to Run hashtag. We would like to hear from you.
You are watching the Ready to Run show, and we'll be right back.
Welcome to the Ready to Run Lab, where we unpack, distill, and simplify elements of campaigns and elections to deepen the understanding of these young people and candidates who are running for office, as well as the electorate. On this segment of the show, we look at rules, strategies, and actions and processes for participating in the 2019 elections. Nigeria's elections are regulated by a set of legal frameworks, and they include the 1999 Constitution of the Federal Republic of Nigeria, the Electoral Act 2010 as amended, as well as INEC's rules and regulations. But the Electoral Act clearly provides that INEC is required to publish the list of candidates that will be running in the elections. And INEC has hinted that on the 17th of January 2019, she will publish the list of candidates for presidential and National Assembly elections, as well as the governorship and State House of Assembly's candidates will be published on the 31st of January. On this week's edition, we will focus on substitution of candidates, because we believe that when INEC publishes this list, we would have candidates who have been substituted by the parties. If you look at the aftermath of the party primaries, INEC announced to the public that there are about 398 pre-election cases that are currently before the court. And on this week, we'll look at what the law says about the substitution of candidates. First, Section 31, subsection 3, talks about what are the grounds for substituting a candidate by a political party. First is on the ground of disqualification for submitting false information in the party nomination form. And Section 31, subsection 6 of the Electoral Act is very, very clear that the court can actually disqualify a candidate if a candidate submits false information on their party nomination form. The second in subsection, Section 33 of the Electoral Act, and the law says that a party shall not be allowed to change or substitute a candidate whose name has been submitted pursuant to Section 32 of the Electoral Act, except in the case of death or withdrawal by the candidate. So this is one of the reasons why a party can't substitute a candidate, where a candidate dies, especially if the candidate has been submitted to the Electoral Commission. The third, very, very interesting, is Section 35. And Section 35 talks about withdrawal by a candidate. This is also one ground for substituting a candidate in an election. Just in case, as a youth candidate or a candidate out there, INEC publishes the list of candidates on the 17th of January as well as the 31st of January, and you don't find your name on the list, provided you've been duly elected as a candidate of your party, there are remedies. And tonight, we bring 4 steps you can take if you are unlawfully substituted. First, study the provisions of the Constitution and the Electoral Act. On the substitution of candidates, you need to empower yourself with the law, and that's what Ready to Run Lab is about. The second, investigate the reasons and the procedure for the substitution, just to check if it's actually lawful or unlawful. But more importantly, gather evidence, because that evidence is what you will use to pursue the cause of justice and the courts of law. Third is approach a lawyer, a qualified lawyer, of course, the one who can defend your rights in the court. And lastly, pursue the cause of justice through the court. Now, the Constitution, Section 285, was recently amended, and the President signed it into law. And what that amendment sought to do was to clearly make provisions for pre-election matters. And the Constitution now defines pre-election matters as follows. First, it says where a pre-election matter or a matter brought to the court can, to a large extent, where you can challenge the actions and decisions and activities of INEC if INEC fails to comply with the provisions of the law. The second ground for also questioning or filing a case in court in the pre-election period is where INEC has not complied with the provisions of extant laws, conducting its responsibilities in participating in an election or in the process of nominating or selecting candidates. And so as a candidate, if INEC publishes the list, and you're very, very sure, and you've got justifiable facts and reasons that to establish that you were unlawfully substituted, you can actually go to the court to enforce your right. The third, and perhaps the most interesting, is pre-election matters can be brought to the court where the provisions and laws and guidelines regulating a party primaries have not been complied with by the parties. We saw that in the aftermath of the elections, of the primary elections. In fact, parties fraudulently wrote letters of withdrawal and submitted to INEC even without the knowledge of the candidates. And so this is one avenue where you can, as a candidate, actually enforce your right. One very, very important aspect of the law that every candidate and even electorate should be very mindful of is the question around timelines. If you don't file your case within the timeline prescribed by the Constitution, you stand a chance of losing out. What does the law say? First, it said all pre-election matters shall be filed not later than 14 days from the date of the occurrence of the event. So you must file your case. You must seek redress in court 14 days after the date of the occurrence of the action or decision that you seek to question in court. The second is that the court has 180 days to actually determine that suit. So the court of first instance has 180 days to determine the suit. The second is, if you're not satisfied with the decision of the court, you know, there's a provision for judicial review, and so you can actually appeal. You've got 14 days to apply from the date of the delivery of the judgment. And so if the court delivers a judgment, you must file within 15 days after the judgment has been filed. And lastly, appeals from pre-election matters shall be heard of or dispensed of within 60 days. from the date of the filing of our appeal. It is very, very important as candidates, you're very, very mindful of these provisions because you can be shortchanged at the end of the day if you do not know the law. Keep in mind, election it's a game that is regulated by rules, so you must master those rules to actually succeed. And this is where we draw a curtain on this week's edition of Ready to Run Lab. You can get more information on this on our website at readytorunng.org. Just sit back for the Get Out the Vote segment on the Ready to Run TV show.